Hi. So today we're talking about an appeal, and it's funny. A lot of landlords are absolutely shocked when they win a case, especially landlords who've done it over and over and over again, right? So they've done it over and over, and they win the case, and somehow the tenant is allowed to appeal. It's like they don't understand it. Like, well, it's automatically assumed, well, I didn't do anything wrong. What did I do wrong? What did the court do wrong? But it has nothing to do with fault. It has nothing to do with anybody getting anything wrong. At the justice court level, you don't need error, because every person, in every case that the justice court hears, every person has a right to an appeal. Whether everything was perfect or everything was flawed, both sides can file an appeal, which means if things didn't go the way you thought they should have and you had a valid reason to win, but for some silly reason you didn't get a judgment in the justice court, you could actually appeal. Now, generally speaking, there's a $500 fee for plaintiff appealing, but there's nothing in the law that stops you from doing that, especially if you have a perfectly winnable case. So why is it that the tenant can appeal? Even if they didn't show up, even if they don't have a good defense, and even if them showing up would have made things worse, the law allows every case that comes out of justice court to be appealed. So the legislature carved out a very narrow set of rules for eviction. So along with the process being very short, and really fast, surprisingly fast compared to other lawsuits, even justice court lawsuits. 21 days is a tiny, tiny amount of time when you consider that other cases take years, even in justice court. And so the legislature carved out this very quick path to judgment. However, it also said, because sometimes people miss court dates, or sometimes people have to work and can't show up to court, but they believe they have a valid basis to file an appeal, or they just want to buy some time. It's kind of a gift, is what the legislature has given tenants in these cases, and the majority of tenants don't take advantage of it, and so that's a fortunate thing for landlords. What's unfortunate is how many of these tenants find out by just doing a quick Google search that they don't need a genuine basis to appeal. They don't need a good reason. They don't even need to show up to the trial. They can wait for the default to come, and as long as they file the appeal within the appropriate amount of time, they get it. And so again, an appeal has nothing to do with error on your part or anything to do with error on the court's part. Every tenant is allowed the opportunity to file an appeal after a justice court judgment. And so if that's happened, then you got to brace yourself for the process and start the entire thing over.